Hello, my name is Blanca Owen. I am director of the immigration program at the Legal Aid Society of Rochester, New York. With the support of the New York State Office for New Americans, we want to present to you this naturalization information. And so we will try to have this presentation today for at least 1 hour, and we have two presenters. One is Joe Kesiris Schaffer. He is an immigration attorney. He has experience in naturalization applications. He has been working for the Legal Aid for more than a year. And then we have Florian Seger. He is a Department of Justice representative, and he also has been working for the Legal Aid for more than a year. He has as well experience in naturalization applications and extended experience dealing with the medical waivers. So Joe Kesiris will be speaking about the basics for how to apply for the naturalization application, and he will also explain what the bars to naturalization, what you need to know for the civic exam, and the exceptions for the English exam. Mr. Seger then will follow with the medical waivers. What is the medical waiver and why you need a medical waiver? If you have questions, please call our intake line. It's 585-232-4090, and make sure you leave a message saying that you want consultation with anyone from the immigration unit. Please try not to leave your personal information here in the comments since we are publishing this video on our Facebook page. So please just call our intake line. Now I will leave all of you with Attorney Joe Kesiris. Thank you.
Thanks so much, Blanca. Yeah, so I'm going to talk about some of the basics of naturalization, but I really want to emphasize, I really want to remind everybody that these are just the basics of it. This is not enough that you should go ahead and do all of this on your own. It's more to help people understand the process of what they're going to have to go through. And then with that, we still always encourage you to work with an immigration attorney or an accredited representative like Florian. And basically, and then if you have any questions, you have somebody who can actually look into it and good answers for you, so you don't guess and you don't basically endanger yourself with negative consequences, with getting in trouble with immigration. All right, naturalization. It's a big word that you might not be used to. Basically, if you are not a citizen of a country, but you are going to apply to become a new citizen of that country, that's usually called naturalization or naturalizing, to naturalize. It's the same in the United States as it is other countries. That word in English, that's usually what you do. Here in the United States, that's the word we use. And there's also usually, almost always, just one form that you're going to use. It's the N-400. But the other thing, just to kind of throw out there that we're not going to talk about today, there are some other ways of becoming a new U.S. citizen, like derivative citizenship, acquisition of citizenship. But again, not going to talk about that. We're just going to do the very basic, normal ways of becoming a citizen. All right. To be eligible to become a U.S. citizen, to naturalize, if you aren't one already, and you're not getting it at birth, that's also something different. basically, you have to be 18 years or older at the time that you file that application, that N-400. You have to have been a permanent resident for at least 5 years, or if you became a permanent resident through the marriage to somebody else, if you personally were the one who got married to a U.S. citizen, then you only have to wait 3 years, but everybody else has to wait 5 years. You also have to have been physically present in the United States for 30 months, or again, it's a little different if you were married to a U.S. citizen, 18 months. You also have to have lived for at least 3 months before you file in whatever state where you are going to claim residence. I'm going to get into a lot more detail about good character and some other bars, things that keep you from being able to naturalize. And then finally, I'm going to talk a little bit about the test. There's an English test and there's a civics test, which is about U.S. history or kind of U.S. Things about the U.S. government or the United States. All right, so first, the permanent resident requirement. It is that you have to have been in the you have to be a permanent resident for 5 years. Again, for the people that aren't getting it through marriage, you have to have been a permanent resident for 5 years without leaving the U.S. for trips of 6 months or longer. There's a lot of different complicated ways of calculating everything, but really just even if you aren't looking to naturalize, if you are a permanent resident, if you have a green card, you don't want to be outside of the United States for more than 6 months at a time. And you also don't want to leave and come right back without talking to an attorney to make sure that you're not going to mess up your immigration status. Again, for people who were married to or who are married to a U.S. citizen, and that's how you became a permanent resident, it's only a 3-year thing. And then the spouse also has to have been a U.S. citizen for the past 3 years. Continuous residence. That does not apply to everybody, such as military members when we're at war, during conflict. But again, don't count on this. Talk to an attorney. I'm going to say that so many times it's going to be really annoying, but I can't emphasize it enough. When you're counting the total number of days that you've been out of the country, it's basically including every time that you are outside the United States. If you're going to Puerto Rico, that does not count because that's part of the United States. But anytime that you're leaving the United States, that's what we're counting up. Okay, jumping over to the bars. So this basically means when you're not eligible, these are things that are going to keep you from being able to apply, and it could actually have other negative effects for you too if some of these apply to you. But to kind of know, there's permanent bars and there's conditional bars. Permanent bars are when any of these things have happened or are part of your past. It means not now, not ever, unless they change the law, will you be able to become a U.S. citizen. Conditional bars, I'll get to that, but that's something where usually you have to wait or some different thing has to change, but you might still be able to become a citizen. All right, but for the permanent bars, those are the serious ones. The biggest thing is if you ever did any severe human rights violations. So just as kind of examples, if you're thinking about if you persecuted people, tortured somebody, kind of stopped somebody from being able to practice their religion, things like that. The other one is if you've ever been convicted of murder. The other part that gets really complicated, and so again, don't feel like you have to figure this out yourself, but just sort of you can kind of have an idea what the immigration attorneys or representatives are looking at. But they're, aside from just felonies, there's these things called aggravated felonies. It means it's a felony that's kind of at that next level, something worse. The hard part is I've had a lot of clients who feel like what they did wasn't as bad as murder. So they feel like, oh, there's no way it's an aggravated felony. That's why you can't make this decision yourself. You need to have somebody else who knows the law help you go through it. But to kind of give you an idea, some of the things that we're looking for is something that we kind of flag us to at least make sure that we want to get into the specific details, that we don't just say, oh, yes, for sure you are or not, without really hearing more. If you were ever sentenced to jail for more than 6 months, or if you even had to do more than 6 months of probation, it's possible you had an aggravated felony. Not for sure thing, but it's just possible. But that's enough that you want to have somebody look into it. So what we would end up doing, and you can do on your own, but anywhere where you got that conviction, you want to get a certificate of disposition. It's pretty much called the same thing across the country. They might have a little bit of different title of like a registration of disposition or something like that. But it's a final disposition. That's what you want to get from the court, and we can request it for you. But that's going to tell you exactly what crime, what the actual conviction is, and that's what we'll go through. And then the next step is, even if you had a criminal attorney at that time, that doesn't mean that they're going to understand how that crime affected your immigration. So that's why you really want to talk to an immigration attorney once you even find out what the actual conviction was. Conditional bars. So these are the ones, like I said, where something might have happened, but you might have to wait, or something else. Typically with these, if you just wait 5 years after the conviction, then you're going to be all right. One of the other things, this is not a complete list. There's a really long list. Some of the things are really obscure and you won't have even heard of, so I'm not going to waste your time with it. But I kind of put together the ones that are the most frequent, the stuff that we see the most of. So if you hear one of these, you think, oh my gosh, yeah, I might have a conditional bar. One of the first ones is any controlled substance violation. So we're talking any drugs, anything that it can be prescription drugs, it can be totally illegal drugs, anything that are drugs, anything that is controlled, even if it's legal in some places, it doesn't really matter. The other thing, this can be even really small. So even if you never had to do probation or serve any jail time, even if you just get a ticket for one of these things, you want to talk to somebody because it could still be a bar. It's the way that I think about it is if you ever had to appear in court, that's typically a good way of thinking about it. Separate is prostitution crimes. If you were a prostitute and got arrested for it, or were not, but pled guilty to it, or if you were somebody who hired a prostitute or tried to hire a prostitute, that could be against you. The other one is convictions of multiple crimes. So that's the other one where if you have a bunch of really small things, but they keep adding up, they could be all things where you only spend 2 days each. But if you add up all those things over time, that you had a total jail time of 5 years or more. I know that would be hard with 2-day things, but yeah, if you're looking at a couple of 2 or 3 month things, over many decades, that could be an issue. The other one too is if you were ever, even one time for any crime, put into jail for 180 days. That's something you want to watch out for and talk to an attorney. If that wasn't complicated enough, there's a thing that we talk about called CIMTs. These are crimes involving moral turpitude. Don't feel like you have to remember that phrase. We will do that for you. But when you hear about it, this is kind of what we're talking about. It's typically if you were convicted of doing some crime against another person, a crime against property, a crime against the government, a crime of fraud. The other one to watch out for, it doesn't always include it, but it can, even when you wouldn't expect it to be, is problems in family court have been considered crimes involving moral turpitude. So even not necessarily problems or crimes, but problems. All right, so back to drugs just a little bit. If there was even a reason to believe that you were a drug trafficker, if for example, you didn't get charged, but there was a big investigation and they had a bunch of evidence against you. So you might not even know about this, but if you were involved in trafficking drugs and buying and selling drugs, that could be bad. So if you even did that and never got caught, talk to an attorney. Because there might be something out there against you that shows that somebody had good reason to think that you were a drug trafficker, even if they didn't prove it. That could go against you. The other one that doesn't even go with convictions at all, but happens way too often is if somebody put something wrong on an immigration application or talking to an immigration officer. It's called misrepresentation. It basically means that you said something incorrect. Even if there was no criminal conviction, that could get you into trouble. Talk to one of us about it, because there are certain ones that are not going to be a big deal. If you put that were living at an apartment, and you put the wrong month, something like that probably isn't going to make a big difference. But there are other ones, like if you didn't, if you said that you had no kids and then later on went to apply for your kids, or things like that. That could make a big difference against you. They could try to say that you were lying and trying to scam the system. Those are the ones that could get you into trouble. So anytime, if you think even something was done on accident, talk to one of us about it before you apply on your own to become a citizen. The other one that a lot of people don't realize is you are supposed to register for selective service. We call it registering for the draft. It's any males between 18 and 26, even if they're not permanent residents, even if they weren't here legally. If you're in the United States, you are a man, and you're here sometime between when you were 18 and 26. You're supposed to have registered for the draft, so that if we ever went into, started a war, that they could call you into service. A lot of the people who aren't here legally are afraid that if they do that, that they, could be deported, or they might not know that that's a thing. So you want to talk to us. There are ways out of getting past this, but usually if you didn't register, you can't just automatically become a citizen. They don't usually just ignore it. You have to kind of do some explaining and some research. Really, to kind of sum it up, is anything that shows bad character, even if it wasn't illegal. So one of the other ones too that is in the laws, I haven't seen it happen, but it doesn't mean that they can't do it. I mean, everybody has seen immigration has been getting much more strict, but committing adultery. So if you cheated on a spouse and it ended up causing divorce, and there's some records of it saying that divorce was caused because you cheated, that technically is enough that could stop you from becoming a citizen. The other one is, there's this phrase called habitual drunkard. I don't know anybody who says that in normal everyday life. Somebody's a habitual drunkard. So don't worry about that phrase. But if you've had drinking problems, even if you don't feel like you're an addict, one of the ones that we say is if you've had 2 or more convictions for driving while intoxicated, or 2 or more convictions with anything to do with alcohol, you want to talk to an attorney before you apply. With all of those, the other thing, even before you talk to an attorney, one of the things that we like to look at, and if at all possible that we can do, is you want to show that whatever bad behavior you had, whatever they consider bad behavior, even if not everybody would, that you did something to make it better, that you did something to remedy it, to fix it, just to improve it. If there are any documents that can show that you've done any things to make those things better, start bringing them, getting them together, take them to your attorney. But really, yeah, anything that immigration might ask you about, that could come up, don't hide it. Bring it forward. We can look at it. We can figure out if it's something you need to put in your application or not. But just because you don't tell your attorney doesn't mean that immigration, that USCIS, can't get a copy of it themselves and ask you about it. And it's a lot harder to try to undo it afterwards if you didn't prepare for it. Same thing as far as documents. If you ever went into any alcohol treatment, anger management treatment, any of those things, get documents together. Those can really make a difference. All right, so now switching gears again, the language exam. So again, there are 2 exams. There's the civics exam that I'll talk about, and the language exam. Pretty much for either of them, some of the best materials, at least in my opinion, to practice are right on immigration's website. The best way that I have found is that really I put 2 things on here. There's an app. If you just, in the App Store, either if you have an Android or an Apple, look for USCIS or civics tests. They have some ones made by the government. Or the other thing I just do is Google the N400, that's that application, civics practice test. And when I Google it, these are the first two things that show up for me. Both of them are good. One of the things you want to keep in mind is if you are looking for something to help you practice, you want to get something that's accurate and up to date, because we're going to talk about it, not today, maybe some other time, but they just changed a bunch of the different questions. They just changed the number of questions and the types of answers. You don't want to find something that's helping you practice for the wrong one, for the wrong answers. So that's another reason why I would suggest going right to the immigration sites materials. For the language test, really there are a couple different parts of it. One is reading. And again, I had put down a certain number of sentences. I think this has actually changed, so I apologize. I can't remember offhand. But in general, you will have to read out sentences. They basically will show you either, the last time we went, they were doing it on tablets, so that they wouldn't have to actually share and have you touch as much and share germs. But in the past, I'd seen it on paper. But basically, they'll give you sentences, and you need to be able to read it out. It doesn't have to be perfect, but it does have to be good enough for the officer, for the immigration official who's there, to understand. And especially, there's going to be looking through keywords. Going back to those practice materials, they have lists of what the keywords are. So you can know anything that's showing up on there. You want to learn how to practice those ones and make sure that it sounds good. Then there's the one that's kind of the flip side of the reading test. It's the writing test. The officer is going to read something to you, and then you're going to have to actually write it down. Again, the last time I went, they were doing it on tablets, so you would write it right on the tablet. You can write really big if that's what you need to do. You just have to write well enough, really, that they can read the letters and the words. So you do have to practice to make sure your writing is good enough. Again, you don't have to be perfect grammar. If you don't use a period or commas, that's probably going to be okay. But the biggest thing is those keywords. You need to be able to spell those pretty close, so that they know that you understand that you learned the material that you needed to. And then finally, the other one that some things might not talk about. They might not talk about in those practice materials. But anything on that big application, the N400, they can ask you about it. And if you don't know how you answered it, and you can't basically answer the same thing to them, that can be a problem, and would try to deny you for it. So that's the other thing, is go through and just practice any questions on there that you understand those questions on the full, even if somebody's helping you fill it out, you need to be able to understand if somebody reads any of those questions to you and how you answered it. Again, you don't have to remember everything perfectly, like if there are different dates of residence where you lived in some different place. That doesn't have to be perfect, but if they ask you who your kids are, you need to be able to tell them who your kids are, and it needs to match your application. All right, the civics test. Again, this has changed. If you have already applied for to naturalize before, I think it was the first of this month, I can't remember the date. It'll be this old one that I kind of have up here on the 100 questions. Now it's something like 120 questions. And the same thing in terms of at the end, the number of questions they ask, that's changing too. And we'll talk about that later. But really, they're going to be asking about different topics. It can be about the system of government now or all the time. And then there are some things that are really talking about now. It's not just about the U.S. history. They'll be asking about who your U.S. state senator is, or who your House of Representatives, who your representative in the House of Representatives is, things like that. Those links that I gave you are going to have all the answers to those general questions that are the same for everybody in the country. But those ones that are going to be specific about where you live, those ones change. And so that one might not be in those updates. There is a website here, cis.gov, citizenship test updates, that will have some of those, like when it has a new president, that'll be updated. But even there, some of the stuff like who your representative is or who your senator is, you're going to need to learn how to look. They're pretty easy to find, but just looking at those materials isn't going to give you the answer. You're going to have to find that. finally, at the interview, the officer, if you were doing it before, they did the whole thing of reading up to 10 questions. Now I think it's going to be 20 questions, and they're going to actually read all of them. But the pass rate I think is the same. I think it's 60%. And so basically, you need to be able to answer, more than half. You have to answer 6 out of 10. So I think that's 12 if it's 20 questions. Again, we'll talk about the more specifics of that, but you're going to have to know most of this. You can't just go in and, probably not. Maybe you're really smart, but most people are not going to be able to go in and memorize this. I've even with people who have been born U.S. citizens, I've asked them these questions, and a lot of times they don't get 60% right. It's not the easiest thing. You really need to practice. I really strongly suggest you practice. If you don't get the language portion of the exam or the civics part right, you do get a second chance. They're not going to fail you right away. They fail that part of it. Any part that you passed, you don't have to take again later. But what they usually do, at least the rules say it's 60 to 90 days later. I've seen it, be something different lately, especially. But they do come back and have you do that part again. But then you don't get more than a second try. If you don't get it on the second try, then they fail everything and you have to start all over again. And so if you're somebody who has to pay the fee for the N400, you have to pay the fee again. And even if you don't, even if you had a waiver for the fee, call us if you have questions about waivers. But with those, you still have to go through the whole process of applying all those things. And if any changes have happened, you have to do it for the new updated thing. You don't get to get those old, the old 100 questions and 6 out of 10. Those things don't apply to you anymore because it's a new application. For English, there are some exceptions. Florian's going to talk about some kind of more extreme exceptions, some waivers. But one of the really basic ones that doesn't take a whole lot is just based on your age. If you have been on the 50-20 and the 55-15 rules, if you are 50 years old and older, and you have been a green card holder, a permanent resident, an LPR as we call them, for at least 20 years at the time that you filed the application, not at the time of the interview, but the time where you actually filed the application, you don't have to do the English part. You still have to do the civics, but you don't have to do the English. The other one that's the same rule is if you are over 55, you only have to have been a green card holder for 15 years. So if either of those apply to you, let us know, or whoever's filling out the application. And it's a little bit different, but you don't have to worry about that language part. But you do still have to do the civics part. For example, if you're a Spanish speaker, you have to take all those questions in Spanish. The other part, like I said, Florian's going to get into a lot more, but are about disabilities that keep you from being able to pass the tests. We'll try to revisit this at the end, but you want to call us if you have any questions. The other one that's a really, really good underused resource is the Office for New American hotline, 1-800-566-7636. Call them if you have questions, if you want to do something and you're looking for somebody to be able to help you. They are really good. And even if they can't directly answer your question, they're really good about knowing somebody who can and referring you over. And then again, here are a couple of links to, I know you can't click on them, I'm sorry, from the Facebook page, but if you can copy them, these are some of the ones that will have good materials for you online. But again, I said that you can always Google them. That's a good way. Then real quick, just in case you didn't know, there are some reasons why you want to become a citizen. One of the big ones is just that you can bring other family members that you couldn't bring, that you could petition for them, that you couldn't do before. When you're a green card holder, when you're a permanent resident, you can, and hopefully you can petition for a spouse or unmarried children. That really expands once you become a U.S. citizen. You can petition for married children. You can petition, at least for the moment, unless something changes, you can petition for your siblings. you can petition for your parents. There are some rules. If you are a citizen but you're not 21, you can't petition for your parents. Or, and you won't know this phrase if it wasn't you, but a special immigrant juvenile, somebody who got status under a special type of visa for juveniles. But again, if you don't know what I'm talking about, it probably doesn't apply to you. But anyhow, if you did that, you can't apply for your parents. But everybody else can apply for their parents. For wait times, it also can be, not always, but can be faster once you're a U.S. citizen. For example, for your spouse, for your unmarried children under 1 year, and your parents, those are usually very quick. You can basically start processing them right away. Those other relatives that you couldn't apply for before, like the siblings, and the married children, those ones you can petition for, but do still have longer wait times. That said, it still works. I have had clients who have waited more than the 10 years and then are able to bring their older married kids to the US. So it doesn't hurt to still petition for them. So anyhow, so those are the big things that I have, and I'm going to pass it over to Florian now.
Thank you, Joe, for this presentation. And I am going to talk about the medical certification for disability exceptions, or Form N648. So as my colleague Joe mentioned before, the language test and the civics exam may not pose a major issue to most of the applicants for naturalization. However, there are individuals who have certain impairments or disabilities that will prevent them from learning English or learning the civics. So what does that mean? Does it mean that these individuals will not be able to naturalize, or is there a way for them to be exempt from the requirements of the language test and the civics exam? And the answer is yes, there is the Form N648, which will help them getting exempt from these requirements. So what is this form? Who is it for? What does it do? And who is authorized to fill it out? We're going to talk about these points in the next couple of minutes. So what is Form N648? So as I mentioned before, this is a form for applicants who seek an exemption from the educational requirements of the naturalization process, and who have certain physical developmental disabilities or mental impairments that have lasted and are expected to last 12 months or more. And these applicants can attach to the application, to the N400, the Form N648, which is the medical certification for disability exceptions. As I mentioned, this is a form for applicants for naturalization. If you are looking for other types of immigration benefits, you don't need to fill out this form, even if you have a mental health condition or a physical disability. So this pertains to the N400 form, and it's to exempt you from showing English proficiency and to pass the civics exam. What does it do? If it's completed correctly, and that's very important, it will exempt you from understanding, speaking, reading, and writing English, and from the knowledge of US history, government, and politics. Who can fill it out? So there are limitations of who the medical professional is, who can fill this form out or who can actually sign off on this form. It is limited to medical doctors, MDs, doctors of osteopathy, DOs, and clinical psychologists. Please be aware that nurses, therapists, social workers, nurse practitioners, or physician assistants cannot sign off on the N648. Even, I mean, it doesn't mean that they cannot fill this form out, but it has to be under the supervision of one of the three categories, the medical doctor, doctors of osteopathy, and clinical psychologists, who will actually have to sign off on that form if they were not the professional who filled it out. Now, this is the form, and this is it's a new iteration of the form. As you can see at the bottom left, it's an edition dating July 23rd, 2020, and it will expire on December 31st, 2021, as you can see at the top right of the form. This form, as if we were going to go page by page, and I'm going to talk about the main and most important points on how to fill out this form and what has to show on it to be acceptable and sufficient or deemed sufficient by the immigration officer. So if the medical professional uses an interpreter, this form starts with an affirmation at the top that certifies that the interpreter is fluent in English and the language of the applicant, and that the interpreter accurately interpreted all the questions and all the answers during this while this form was filled out. The form starts part one with information on the applicant. These are demographics, self-explanatory. It's the name, given name, middle name, and who the physician is, including their address. Also, at the bottom, we'll see some applicant information that includes their alien registration number. This number is usually can be found on the green card or the lawful permanent resident card. It's the A number that has to be on this form. Also, the applicant's US Social Security number needs to appear here. Date of birth, the gender of the applicant, their phone number, and email address, if any. Part number two is about the medical professional. So the medical professional needs to fill out this information with their name and the address of the practice or the hospital or the clinic. And it's very important that they also include point number three, their license number and the state that they are licensed. Also the phone number and an email address if there is any. And then number 7, they have to check off one of the 3 licenses that, as I mentioned before, can actually fill out this form or sign off on the form. And they also need to provide information on the medical practice type. This might be like a general practitioner, or it might be a specialist like neurology or psychiatry. Part number 3 is the information about the disability or the impairment of the applicant. And basically what CIS or the immigration officer wants to see here is the code of the impairment or the disability. And this code is taken from the DSM-5, actually, which is the most recent edition. If you're not familiar, DSM stands for the Diagnostic and Statistical Manual of Mental Health Disorders. So all these illnesses that show up in the manual have a code, and that the name of the impairment and the code has to be mentioned in this section. If there are multiple impairments that will have a negative impact on the applicant's ability to learn English or to learn the civics, all these impairments have to show up here with their own code. Part number 3, point number 2 is it asks the basic description for the disability, and here the provider can actually write down in their own words what the definition of that impairment or disability. But I have found it's a good practice to actually take directly from the DSM the definition, and just mention that this is a quote as taken directly from the DSM-5. Number 3, when did each disability or impairment listed begin? So sometimes it is possible to put a specific date, but it's okay if the professional puts unknown if the applicant has a history that cannot be necessarily verified. We don't know the onset. They're coming from a country that didn't provide them with some medical history, or these illnesses or impairments have not been necessarily diagnosed in that country. Date of diagnosis, it's when the professional who fills out this application diagnosed this illness or saw the patient for the first time. Number 5, it's a question, what caused the disability? And sometimes it may be known, or sometimes it might be an unknown cause. And again, it is okay if the provider puts down that the cause is unknown. Just to mention here that illegal drug abuse or drug use is, and we're going to talk about that a little bit later, is not going to form a basis for this exemption from the required tests. Number 6, it requests the provider to give information on how they diagnosed the patient, and this can be interviews or direct observation, or certain tests that are administered, and then the name of the test needs to be mentioned here. Number 7 needs an explanation of the severity of the impairment or the disability, and what the symptoms are, what kind of tests were conducted, and it's always a good practice when a specific test that the provider used, that they mention the score. Okay, so it's not sufficient to just write down that this is the name of the test, but what the score was, and what the score was that the applicant obtained, and what that actually means, that specific score. Number 8. This is a description of how this impairment or disability affects the daily life of this applicant, how debilitating this impairment is, and also how it negatively affects the ability of the applicant to learn English, to read, to write, and to understand, including memorizing new information that is necessary for the civics exam. Number 9 is very important because this exemption is based on the fact that the disability or impairment has lasted or expected to last at least 12 months. Okay, so if this is something temporary that only what the specialist thinks it will last for a couple of weeks or months, then this is not sufficient. It has to be something that is an extended illness. Number 10, out of the disabilities and impairment that we mentioned, or that the professional mentioned at the beginning, they have to write down what are the disabilities that will expect to last 12 months and are the ones that are preventing the applicant from taking or learning the new language and retaining information regarding the civics exam. Number 11, as I mentioned before, is related to illegal use of drugs. If the answer here is yes, this applicant is not going to be exempt from the requirements of knowledge of English and the civics. So we can actually, or the provider can stop there, because the form N648 is going to be deemed insufficient. Number 13 is probably the most important part of this form, which it is the nexus between the impairment or the disability and what body parts this disability affects and what the role of that body part plays in learning English and obtaining learning civics. So here, what the immigration officer wants to see is a clear description between cause and effect and how that impairment or disability affects the ability of the applicant to learn English and civics. So this needs a very detailed description of what is affected, what role that part or function plays in learning a language and retaining or learning new information. Number 14, so here, based on the provider's professional opinion, the provider states that this applicant will not be able or is unable to read English, speak English, write English, or answer questions regarding US history and civics. So all these four I would say, well, necessities or impairments can be actually checked off, or only sometimes an applicant is able to speak English but is not able to read or write English. So the provider deems that sufficient and keeps like speak English unchecked, and just checks the points that he thinks that this applicant cannot master. Number 15, it's related to the date that the most recent date that I'm sorry. It's the date when the applicant was first examined regarding this impairment or disability, and that's usually the first time that a provider sees the applicant in his or her practice. Part number 3, information about the location or of the clinic or the office of the provider, and again, if it's the same information that we mentioned on the first page, it's sufficient just to check same as business address. Number 16 is related to the date when the applicant was last examined, and it's always a good practice to see the applicant as close to the submission of the application date as possible. So discrepancies in dates, or when sometimes months pass from the time that this form was filled out before the application for naturalization is submitted, can raise a red flag, and that's why it's a good practice to submit an application very close to this date. Number 17, so here the form asks the question whether the person who filled out this application is the regularly treating professional of this applicant. The reason for this is sometimes applicants might, or some providers in their professional opinion may not feel that the applicant has some impairments or disabilities that will exempt them from the test. In that case, the applicant may seek an advice from another physician and just go and check with somebody else. And so basically this question is to prevent that, like seeking a better doctor who may help. And if the form is not filled out by the regularly treating physician or specialist, there needs to be an explanation why that is not the case. And sometimes it's okay, because sometimes general practitioner or a family doctor may want to refer the applicant to a specialist, let's say to a psychiatrist or to neurology, and which is okay, but it needs to be explained on the form. Number 18 wants to ask about questions about how long the treatment is going to be, or how long it has been in place. Also 19 refers to the treatment, and it refers to how often is this patient or applicant seen in the provider's office. And it can be weekly, monthly, yearly. Obviously, the more often means that the severity of the disability or the impairment is higher, and that will actually help this applicant with the application. Number 20, in case that this application is not filled out by the regularly treating doctor, then number 20 wants the information on that professional and their name and the address of their practice. Number 22, here is the explanation why this is, if it was not filled out by the regularly treating professional, why not? And it's okay to, and any reasonable explanation will be accepted here by USCIS. Question number 23, was there an interpreter used? And the answer is obviously is yes or no. Some additional comments can be entered here. And then part number 4 provides information on the interpreter, being that either in person or by phone. And again, it name, address of the interpreter, and the interpreter doesn't have to come necessarily from an agency or organization. Oftentimes, there are family members or friends or community members who, excuse me, accompany the applicant or the patient to their visit with the doctor, and that's okay. However, the interpreter has to fill this out, the interpreter certification, and again, it asks the language and the date when they interpreted for this patient, including signature if it's an interpreter in person, and the date of the signature. Obviously, the date of the signature has to match with the date of the appointment. So it's important to check that all dates are matching. Questions whether it was an interpreter over the phone or in person, and at the bottom, part number 5, this is where either the applicant or a representative needs to sign off, and they put the name of the applicant, the name of the medical doctor, and the signature and the date when this appointment took place. Again, it's important that the date matches with all the other dates on this application. Part number 6 is the medical professional certification, which attests that indeed he or she saw this patient on such and such date, and if there was no interpreter needed because the professional speaks the language of the interpreter, and many times that is often the case, especially with Spanish-speaking population. It's sufficient that the professional just mentions that he or she is fluent in the language of the patient, and there was no need of an interpreter. Again, this part requires an ID. Basically, it certifies that the professional ID'd the patient, and this can be a state ID, or they can use a permanent resident card or any other type of identification document, and just there's a need to check one of the boxes, and then if it's another type of identification, then it's just mentioned what type of identification it is. The signature of the licensed medical professional at the bottom of the form, including the date. So this is basically the form that has to be filled out by the professional, and that needs to be submitted together with the application. So it's very important to remember that it's not always the most severe disability that will grant this exemption, but it is the how well the application is filled out and how detailed it is, and this is basically the job of the person, of the professional who fills out the form. There is nothing that the applicant can do or should do, or the person who helps the attorney or a representative or the preparer. Obviously, they cannot influence, and they should not influence the decision of the doctor whether to grant this kind of application or not. So there are several important things from this application be remembered when filled out, and so I'm just going down in order. Always be sure that it is the most current version of the form, and the best practice for that is to check actually the USCIS website Form N648 because that is always going to be up to date, and it's going to contain the most recent and the form that is actually in use. Only authorized medical providers can sign off on the form. As I mentioned before, it doesn't mean necessarily that it is the provider itself that fills out the form. Sometimes they are very busy and they delegate this to one of their staff members, but it has to be their signature, and it has to be under the guidance and supervision of that medical professional. All questions have to be complete on the application. Okay, if something is missing, there should be an explanation why it is missing, but it will raise red flags with USCIS. It's important that there are no date discrepancies. As I mentioned before, that all the signatures of the date of the visit, that is the professional, the interpreter, if an interpreter is used, and that the patient, they're all matching with the same date. Form is, the Form N648 is valid for 6 months. However, once submitted, it is valid until the date of the interview. So these forms basically, and I'm not going to talk here about oath waivers, but if the applicant has to be able to answer the questions on the N400 application. If they are not able to do that, and then they have to be able to do it with the help of an interpreter. But if they're not able to do that, then we're talking about a different process, which is an oath waiver, and that would be a completely different presentation on who can obtain an oath waiver and under what conditions. The medical provider has to use the most current DSM form and the description of the medical disability, including the code. The medical provider has to describe in great detail the disability and how it impairs the applicant to learn English and civics. It shouldn't be a general description, okay? So they shouldn't use the term patients with this impairment or disability and so on. They have to mention the patient by name, okay? So it should, let's say it's it's Mr. John Smith, so they shouldn't refer patients, but instead they should always use John Smith cannot do this or cannot learn this kind of information because. So avoid generalities. Old age and illiteracy do not form a basis for the exemption. So basically, because someone is of a certain age or because they are illiterate in their own language, will not be sufficient to grant this exemption. It has to be an impairment or a disability. So old age and illiteracy are not impairments or disabilities. So that is an important thing to remember, that exemptions are not granted based on plain old age and illiteracy. The same applies to applicants who have certain visual and hearing and speech impairments. Their USCIS will provide a sign language interpreter, or they will provide certain accommodations if there are visual impairments or hearing impairments. So it's not sufficient to be visually or hearing or speech impaired. Also, it's important that medical providers, and it's usually difficult because they tend to use specific medical terminology that is easily understood by a medical professional. However, what immigration wants to see here is explanation in plain English. The officers who will review this application do not necessarily have a medical training background, so it has to be described in a way that makes sense to someone who has no medical training. Also, it is very important that the medical provider clearly states that improvements to the applicant's medical condition are likely. And the problem here is that sometimes the professionals are hesitant to put definite terms down or time spans, because you don't know how medicine evolves, and something that cannot be cured today doesn't mean that there won't be any cure in like a year down the road. However, immigration wants to see very clearly that there are probably no improvements for disability, for this kind of impairment or disability. So it's as the professional sees things in gray, immigration wants it either black or white. If a cognitive test is used or to diagnose this impairment, it's always a good practice to include the name of the test and the score attained by the patient or the applicant and what that score means. Sometimes red flags are raised if these impairments don't show up on an applicant's previous immigration documents, and it's a good practice, if it's possible, that the professional mentions on or adds it as a note to the application that sometimes these kind of impairments or disabilities are not obvious, or they the applicant comes from a country or a place where these diagnoses are not routine, and it was very hard to diagnose it back maybe many years ago, and so the lack of this showing up on a previous immigration matter is not necessarily, or should not necessarily, be a red flag. This was it, and again, if more questions or clarifications are needed, please don't hesitate to contact Legal Aid Society.
Thank you, Florian.
Thank you.
So we are pleased to bring this type of presentations to our community. Before COVID, the Legal Aid Society used to go into the community, to organizations or churches, the community itself, to talk about all these immigration subjects. But because of COVID, we cannot go to you physically, so we are trying to do this using, taking advantage of the technology. So please keep in mind, do not leave any comments, especially do not share your personal information here in the Facebook page, call our number 585-232-4090 and leave a message to the immigration unit. We will try to come back probably in January with a presentation regarding the changes that was recently issued by USCIS regarding the civics exam. I hope this was helpful for you. Thank you very much. Have a great day. Bye-bye.